It is March 3rd of 2026. March Madness is just beginning, and this is the Court Gallery. Ladies and gentlemen, we're staying in Michigan all night tonight. We're starting off with Judge Dad, and he's disappointed as disappointed can be in several people. It's a little bit of a potpourri in Judge Dad. We're going to be with him for, about an hour. We're going to move very quickly into Judge Simpson's court docket with landlord-tenant situations, and we're dealing with Arbor One craziness, and it's all about the money, ladies and gentlemen. And we're going to wrap things up with a preliminary hearing from with a gentleman by the name of Brandt. We've seen before in front of Judge Middleton. It all starts right now. Mr. Brandt's the deaf guy.
Jonathan Ryan Wilkinson, 23D144450.
Good morning, your Inspector Jonathan Wilkinson.
Your name?
Jonathan Ryan Wilkinson.
So it looks like defendant's here for failure to pay $651. How is he going to proceed here?
Judge,
Plus a warrant fee.
what happened with this, he had a case similar to ours in front of Judge Hessen. Looks like he was transferred over to the Wyandotte Court for supervision through their program. In this court, this file was closed out before that one was closed out. He appeared in front of Judge Hessen last October. She gave him 60 days jail, I think, in conjunction with Judge DeSantis in the 27th District Court to close out that file. He served that time from October 6th until I think it's December 13th. We would ask the court to close this file, time served.
You still got warrants out.
He does their first pay civil.
Did he ever pay any money on Judge Hessen? The case of when are you going to get your life in order?
As soon as I have my license, I'm very close. But
Where do you work?
I've just been working side jobs on Facebook for now, and I've done a little bit of work for Mr. Loveday on the side. But on top of that, I've still been going to the guidance center, and they're helping me look for work as well.
He was supposed to pay $50 bi-weekly on this beginning March 1 of 25. It looks like August 1 of 25. He didn't pay anything.
Didn't have any money at the time.
Did I not tell you to come and talk to me if you didn't have the money? Did I? Why didn't you come and talk to me? I told you to come and talk to me if you didn't have the money.
I'm still worried about the probation from Wyandotte, and I'm still trying to just follow with everything they wanted me to do. They had me going all kinds of therapy and all the places, rehab for a little bit, left the rehab, and then basically I turned myself in, and here I am now.
This is a 2023 case. We're still fooling around with a 2023 case. Do you have any money with him today?
He's barely able to keep his residence. He's continuing to get his house.
Why didn't you go and apply for jobs and get a steady job somewhere?
I'd like to, but I mean, it's like pulling teeth. It's like, I know I don't have my license, but I know that I can still have an ID and like be capable of working in a company. But I've just taken my exam for now. Got to put my actor to that. Um, as far as if my mom, she's been there for me, and
What days were you in custody on Judge Hessen's case?
initially I first went in on October 6th, but I didn't see Judge Hessen until November 4th.
And then you were in custody until December 13th.
So it's yeah, December 13th. She accredited me 50 days.
You were in custody on Judge DeSanto's case beginning October 6th, is that right? Kids, wife, anything?
No. So I got my dad's kind of like, he's got cancer and whatnot. And I see my starts to really just keep myself.
You don't deserve a break, but I'm gonna give you one. I'm gonna just give you credit for time served on Judge Hessen's and close this.
Thank
You gotta grow up. You're 39. They don't give us like 487 years on this planet. Good luck. People advance. Brandon Ross Pantel, 24B147651. All right. Good morning. Your name? Your name?
Brandon Ross Pantel.
I have a charge here. I placed you on probation. The charge here was fraudulent schemes. There was $640 ordered in restitution. We issued a show cause. I'm going to read the charge. Failure to register, attend, and complete the positive strategy program with 8-week follow-up. That's count 1. Do you understand the charge? I'm sorry.
Yes, Your Honor.
Count 2 alleges that you failed to pay your fines and costs as ordered. Do you understand the charge?
Yes, Your Honor.
You have 3 prior technical violations according to this. Therefore, your probation could be revoked on this and you could be incarcerated for a period of 90 days. Do you understand that?
Yes, Your Honor.
And did you sign, read, and understand the advice of rights?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. You understand that?
Yes, Your Honor.
All right, you have the right to a lawyer. I'll be happy to provide you with one at public expense. Do you understand that?
Yes, Your Honor.
Would you like a lawyer?
Yes, please.
Okay, so I'm going to enter a not guilty plea. We're going to have a revocation hearing here. We'll set you up with a lawyer. You'll talk to the lawyer, and I think Haynes has our probation
He
done.
does.
So you're gonna meet with Mr. Haynes, and Mr. Haynes will come back in here with you, okay, after you guys are done. All right?
Your one is that was Brandon Pantel.
I'm gonna need Beth on this one, Jessica. Jessica?
I'll grab Beth. This is Betsy.
Thank you, Pantel. Your name, sir?
Brandon Pantel.
All right, so we have a charge here, and he has, by the way, prior violations. 3 prior technical: failure to register, attend, and complete the positive strategies program with 8-week follow-up, and failure to pay his fines and costs as ordered. Those are the 2 charges. How is he going to proceed?
Yes, as of the date that the violations were filed, February 11th, he's pleading guilty to those, but I would indicate the situation's kind of correct.
All right, sir, is that what you want to do, is plead guilty?
Yes, Your Honor.
All right, if you plead guilty, this will be 5 violations, and your probation could be revoked, and you could be incarcerated for 90 days. Do you understand that?
Yes, Your Honor.
And again, did you understand all your rights?
Yes, Your
You
Honor.
did sign it and read it and understand it?
Yes, Your Honor.
If you plead guilty, you're giving up all those rights, and we're not going to have a hearing or a trial of any kind. Do you understand that?
Yes, Your Honor.
All right, through the charge that you failed to register for, attend, and complete the positive strategies program with 8-week follow-up How do you plead?
Guilty.
Did you fail to register and attend and complete that program as of the date of the issuance of the show cause?
Yes, guilty.
You failed to do that, though?
Yeah.
Is the count 2? Did you fail to pay your fines and costs as ordered, the balance owing as of the date of show cause being 465? How do you plead? You failed to pay all your fines and costs by that date.
Yes, guilty.
Anybody force you to plead guilty?
No, Your Honor.
I'll accept your pleas to counts 1 and 2. Ms. Wild, your name? Tell me how he's doing real quick.
Other than those 2 violations, he has all his other terms and conditions met, Your Honor, all his other programs. His big issue, I think, overall has been getting through the Positive Strategies program. He did pay his $515. I'm not sure if council mentioned that, but excuse me, his fines and cost balance. He paid that after the show cause was issued, Your Honor.
How far along is he in the Positive Strategies program?
He is not in it at all. He informed me that he was having issues with the Positive Strategies program. We have an equivalent through Class
I
A.
mean, he was having problems with it, issues with it. What?
I would let him explain, Your Honor, because it's been a year that I've been trying to get him to comply with this program.
It was in the last few minutes, I'm not sure if Ms. Wild's got it yet, but, Mr. Van Hill showed me on the screen that he is enrolled, starts on March 7th.
March 3rd, or March 7th, yeah, it's Saturday, 9 to 3.
And I forwarded, we went through his phone and forwarded the email to Ms. Wiles, so hopefully we got that recorded.
What is the problem with the program?
It was my job, I'm a truck driver, and the other class where they wanted me, I worked all that time, like I have 3 people to support, and I was trying to let them know if there's something else I can do, because the class I could only take was like at 6 o'clock at night, and I'm driving, can't get in the vehicle, can't lose my career. Everything's hard, like I worked from, at that point, my schedule was from 3 in the afternoon till 11 o'clock, 12 o'clock at night, Monday through Friday.
And they only do it at night?
Yeah.
So in that, what we did was we referred him over to Class A that has an equivalent program. They have a one-time program that he could attend and knock it out all in one day. They do the follow-up and everything. I referred him to that. He still didn't get involved in that. So by the time I issued the show cause, he paid for the Class A program. I did receive the receipt that council just indicated. It didn't have the date of attendance on it. I emailed Class A this morning, finding out that he enrolled in it again after the show cause. And I haven't heard back from them to confirm the date. So it does appear that he paid for that alternative program. He's been given lots of options with that. Like I said, it's been a year. So if he's scheduled for March 7th, that's great. But again, this is the 2nd violation for this. His deferred judgment date was February 12th, Your Honor. We've already had it extended once for him to get through these terms.
Hey, you were back in here in August on the failure to attend the Positive Strategies program.
Yeah, I have this.
You didn't tell me anything then about this being so impossible for you to attend, did you?
I always.
No, I don't want to know what you told me.
Yeah, I did.
Hang on. So you were telling me you just couldn't do it?
I just said it was hard. I didn't understand how I could do it, because I was a truck driver. I'm a truck driver, and they only offered that class at night. And during my work schedule, I couldn't. I asked my employer if I could change like routes or anything, and that was the route I was hired for. I have 3 people to support. We have 1 income and 1 vehicle. It's like I can't lose a job. Like, and it sucks. But like my family comes. Can't lose a job in my family.
Mr. Haynes, what did you tell him?
Whatever. But I did sign up for this class. I had it Monday, this Saturday from 9 to 3. The Zoom. I got all my receipts and.
I don't know how I can do anything other than enter the conviction though at this point. I mean, he hasn't, the problem is here that you can only be on that status for 12 months and we're past the date. I've either got to let it go and dismiss the case, which I can't. I can't extend probation. I mean, it just seems to me. You know, look, I can appreciate your dilemma.
Very apologetic, I'm sorry.
Well, I know, but you could, pardon me?
I said, once just. I live paycheck to paycheck.
Most people do.
I know.
Can I see the police report?
Yes.
Just relax, Mr. Pantel. I mean, I'm gonna miss Mr. Eanes when he leaves here. You just does such a good job. I mean, you went and cast a check where you didn't have sufficient funds in the account. This could have been a lot worse. So when you do these kinds of things, this is what happens. I mean, you can't just blow off a court order. I understand you had some issues with your employer, but the positive strategies with 8-week follow-up, when would they have had to explain what days they would do that and times?
The initial program, which is about 3 hours long, they typically do that on either a Tuesday or a Thursday. That would probably be run about 5 p.m. to 8 p.m. or 6 p.m. to 9 p.m. The follow-ups are 1 hour long, and they are typically during the week. I believe right now the follow-ups are on Tuesdays or Wednesdays from 6 p.m. to 7 p.m., Your Honor. I might be off by an hour on those estimates, and the program is offered at least once every 6 weeks.
How much do you make in your employment?
It depends, like.
Well, if you're
how
working,
it's scheduled.
if you're working 3 to 11, 5 days a week, how much do you make?
Okay, but $800-900.
After tax? And I don't really have a choice but to accept the plea and revoke his status, Mr. Eanes. I'll let you say anything, but I don't think I have a choice. I mean, he didn't do the program. And I don't think I would have just ignored his request if we were back here in August or September and he was telling me, hey, it's impossible. I can't do it. I can't get to work. I'll have to quit my job or I'll get fired if I have to go to a positive strategies program. Do you want to say anything else?
Judge, is that any more the Trump thing closing the file at that point, or is he gonna be extended?
Well, here's what I'm doing. I'm looking at Heather, I'm looking at this and I don't think this is on his record. The 771 status is revoked. The conviction's entered. We're gonna set a sentence date. Did you ever go over and get fingerprinted over there at Brownstown like I told you to?
Yeah, did that.
You went back in January of 25? Yes?
Yes, all right.
Let me see. I don't know why it's not on his criminal history here. Must have. Heather, I want you to check on the end of this. I'm gonna set a sentencing date.
Okay, Judge.
And you should continue. I just can't. I'll set a sentencing date. We're gonna revoke his status, enter the conviction. And I'll set a sentencing date. And hopefully you'll be well on your way on the program with the Class A Training Center. So let's give him a sentencing date on because I'm gonna sentence you anew now. We'll give him a sentencing date, say in April sometime, Heather.
Judge, the
Okay,
new program he's doing is a one-day program. If he attends it on the seventh, he will be done on March seventh, just
Right.
so that you.
Well, we can do it in March too. I mean, I don't care.
do I do March 31st, Judge?
Sure.
We could do March 31st at 8:45.
Yeah, that's what we'll do. And why wasn't he here back on March the 12th? Or February the 12th? I actually said on February 12th, defendant failed to appear, conviction to remain on record, bench warrant to issue. We issued a bench warrant on February 12th, and then you walked in, it looks like on February 18th. Am I right?
Yeah, I didn't know I had to cure the 12th. I found out that I had a bench warrant.
Okay,
And I didn't know I was supposed to appear.
you go take care of that program. I'm not gonna be overly difficult. You make sure you get the program taken care of, and I'll send you March 31 at 8:30, did you say?
8:45, Judge.
8:40. Okay. You go down, I'll get your notice, and then we'll see you back.
Just over March 31st, if he has the program done, you might be looking at closing this out.
I might find him a little bit.
Anything else that?
No, I just can't, I can't dismiss, or I can't dismiss the case though. But I might find him, I don't know. I'll have to look at it. Okay?
Thank you.
All right, good luck. Fernandez, Derek Tanbelda Fernandez, 25W707530. Your name?
Morning, Your Honor. Chris Shank, you hear my client. Stands to my left, sir. Can you say change for the record?
Derek Fernandez.
So he's charged with failing to attend the domestic violence program, the one-day program on October 7 of 25. And he's also charged with failing to provide proof of completing, it looks like 31 hours of community service by October 20 of 25. How is he going to proceed?
Your Honor, in this circumstance, you understand that he did not do it within the time division, so he would not be asking for a contested violation.
So he's going to plead guilty?
Yes, Your Honor.
Is that what you want to do, sir?
Yes, Your Honor.
If you plead guilty here, this would be 3 prior technical violations. Or 3 technical violations. Your 7694A status could be revoked, conviction entered, and since this is a domestic violence charge, you could receive 93 days on this. Do you understand that?
Yes, Your Honor.
And did you sign, read, and understand an advice of rights form here today? Or not?
Judge, if he hadn't done that earlier, we can go through that.
You are presumed innocent. They have to prove you guilty by a preponderance of the evidence. If you plead guilty, you're giving up all the rights on the advice of rights. You're giving up your contested right to a hearing, your right to question their witnesses, your right to bring in your own witnesses, your right to testify or remain silent, your right to bring in your own witnesses. If you plead guilty, you're giving up all those rights. We're not going to have a contested hearing. Do you understand that?
Yes.
As to count 1, for the charge you failed to attend the domestic violence program, how do you plead?
Guilty, Your
You
Honor.
failed to attend the one-day domestic violence program on October 7 of 25.
Guilty.
Did you fail to attend that program on October 7 of 25?
Yes.
Is the count 2 that you failed to provide proof of completing 31 hours of community service by October 20 of 25? How do you plead?
Guilty.
Failed to do that by that date?
Yes, sir.
Anybody force you to plead guilty?
No.
Accept your pleas.
I have that police were taken on this back on December 4th. He pled guilty to count 1 and we dismissed count 2. He did provide proof of completing community service and it was done prior to the due date. It was
Hang on a second. Oh, I see. Yeah, he didn't show up for sentence.
Yeah, there was a situation, so you had ordered him to come back for a sentencing date on January 6th. You ordered him to get a job and provide proof of mental health treatment. He never showed up and then he went for warrant status.
Why not?
He was hospitalized, Your Honor, from January 13th to January 29th.
Okay, well, why didn't he come in this last month?
I spoke with him, Judge. I think that he had some trepidation, but he did come in on his own volition today.
We have the health records,
So I did get proof from Team Wellness that he is back engaged in treatment.
but he was in treatment.
I didn't have proof that he was in treatment before. My concern is that between the last time he was seen with you and now, is currently under investigation with Brownstown for terroristic threats. So there's been a lot that's been going on between when he was last seen and now turning himself on his warrant. So things are still pending, charges haven't been placed yet, they're still searching and investigating that. Last time they talked to Brownstown, which was about a week or two ago, but I'm concerned there's some deeper things that are going on here with Derek.
And you dismissed the failure to complete the 31.
Yeah, so he completed it.
Dismissed that on December 4th.
He completed them at ChristNet. ChristNet emailed me and said it was their fault. They thought they sent it over and they forgot to. He did complete them in time and they were supposed to send it over, but they didn't.
Is somebody here with you?
Oh, yes, my dad is here.
Terroristic threats to who?
He, if you want me to read, this is what I received from the police. He was posting threats on X, which is now was Twitter, and was tagging federal law enforcement agencies. The threats included blowing up ICE agents in neighborhoods, sneaking bombs onto planes, and possessing child pornography on his phone. Officers and TSA agents went to his home on January 29th. They ended up committing him to the hospital because he fought with police. They were then executing search warrants at that time, Your Honor.
He has not been charged.
He's not been charged as of yet. I emailed them back about 2 weeks ago. The officer stated that they're still under investigation at this time.
I've tried to be understanding with you, sir, in the history that you have. I'm really trying to be understanding, but and I don't want you to talk about that case. You've not been convicted. You've not been charged. In all honesty, it's inappropriate for me to take that into consideration as of this point. Do we have the proof? I'm sorry. I think you said we don't, you proof that he's attending treatment again.
Yes, I just received a letter from his therapist. I believe it's.
We don't have proof that he did the inpatient. Correct? He was inpatient, right?
Yes, he was hospitalized inpatient from the 13th to the 29th.
I don't have proof of that. All I know is that at the end of January, he was committed for sure based on what I received from the police. But I don't know for how long he was there. I don't have proof that he was committed that day.
Sometimes judges. What is that? Is this going in there? Or is that trains beating each other? I don't know how I want to proceed here. I've got to think it through. And I've accomplished nothing here today. All I did was reiterate that a plea was taken back on December 4th. I'm not very happy that he didn't show up on December 4th under the circumstances. I can let that go. Sir, no violations of law.
Okay.
No violations of law.
Yeah, yes.
Can't violate laws. I'm going to assume you didn't do this, and I'm talking about what she's saying. Threats. Very bad. Very, very, very bad. My inclination right now is to revoke his domestic violence 7694A status, enter the conviction. But I don't need to make a big rush into this. I'm going to adjourn the sentencing again for a couple of weeks. Let's give me a date, Heather. The end of March. No violations of law, sir. Do we understand that?
Yes, I understand.
Do March 31st at 8:45.
Again, I cannot reiterate enough how inappropriate it would be to sentence him based on a violation of law when he hasn't even been charged with it. And that's what's kind of throwing me here, but it scares the devil out of me when I hear these kinds of things. We don't get to threaten people, and nobody should be able to do that. And that's that. I'll give you that date. Go down, get your notice. No violations of law is a condition of your bond. Do you understand that, sir?
Yes, I understand.
I want to make sure. Do you understand what I'm telling you?
I understand, no violation, or.
And you keep going to mental health treatment. You understand that?
I understand.
Thank you. Pete's.
Yeah, that's.
Bring them in. I gotta do a signing on record. Michael Jeffrey Teets, F 264001. A and B. Officer, your name?
Officer McCardle.
Officer, raise your right hand. You solemnly swear or affirm under penalties of perjury the testimony you've given these proceedings will be the whole truth help you got.
Yes, Your Honor.
Okay, go ahead.
On March 2nd, 2026, at approximately 21:32 hours, officers Jarmo, Miley, and Hunter were dispatched to the Flat Rock Mire in reference to a male with a knife threatening an employee. Upon arrival, officers Miley and Hunter made contact with the subject inside the front entrance of the business. Officer Jarmo arrived and made contact with the complainant/victim, Jeremy M. Roos. Contact with the victim. Roos stated that he is the manager of the store and was alerted by an employee of a suspicious male that had entered the store. The employee advised that the male had a knife on him as well. Roos was able to locate the male, later identified as Michael Teets. Roos began to stand in the aisle near Teets and observe his actions and to identify if he had a knife on him. According to Roos, Teets began to question Roos why he was standing near him in the aisle and why was he watching him. Roos informed Teets that he was the manager and he was just walking around the store. Teets accused Roos of watching him and he positioned himself into a fighting stance while staring at Roos. Roos advised that Teets had puffed out his chest and clenched his fist while speaking and staring at Roos. Roos stated that he observed the knife on Teets' person. Teets never reached for the knife, brandished it, or threatened to use the knife on Roos. Roos stated that he was nervous that Teets would use the knife against him, however, and he left the area out of fear of being stabbed. Roos began to contact the Flat Rock Police Department to report the male inside the store. Roos further stated that he went to a different location in the store while he was on the phone with the police. Another employee approached Roos and informed him that Teets was asking for him as he was going to mess him up. Roos stepped outside of the business to wait for the police to arrive. Roos advised he wanted the male trespassed from the business and he would like to pursue charges.
What business was this?
This was Meyer, Your Honor.
All right, based on your sworn testimony, I find that the crimes of disorderly person, public intox, and assault were committed, simple assault. There's probable cause to believe those crimes were committed by the defendant. I'm going to authorize the issuance of the complaint and the warrant on those charges. You'll just give me 1 second. And Mr. Haynes, your appearance.
Thank you, I'm Gilwood Haynes, that's Michael Teets.
Mr. Teets, your name.
Michael Teets.
All right, for purposes of arraignment, how does he wish to proceed?
We wait for formal reasons.
Entering a not guilty plea on both of these. Sir, I'm going to advise you of your rights. You do have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes, sir.
You don't have to choose to submit to questioning with law enforcement officials, but if you choose to, you have the right to be represented by your lawyer at that questioning and again at all subsequent court proceedings. You understand that?
Yes, sir.
I'll give you a court date, March the 19th. That will be your pretrial date, March the 19th, and that will be at 10:15. Does your client have a record?
Does he had a OWI from 2024, he tells me successfully completed probation on.
Anything you'd like to say regarding bond?
Good, I think that's all he's got. I know this is a quasi serious charge. He doesn't have any money, does side jobs, can't come up with much as far as bond, doesn't sound like he could come up with more than $100 to get out. And I think that, this court's not in session next week, and then that's, here in the spot rock case, the 19th, so he would be stuck in custody until, it's my understanding, he's got a court date next week, Judge Bassett. And for which he's got a personal bond on the 12th. Under those circumstances, I ask the court to consider a personal or very long bond.
Officer McCardle, anything?
To the courts, Your Honor.
You cannot leave the state. These are your bond conditions without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. You're not to purchase, possess, or consume alcohol. You're not to purchase, possess, or consume marijuana. You're not to purchase, possess, or consume illegal controlled substances. You're not to possess any firearms. You're not to possess dangerous weapons. You're not to enter the property address at 26100 Vreeland in Flat Rock or any other Myers store. You're not to have any contact with employees of the Flat Rock Myers store. You're not to have any contact with Jeremy Roos. You cannot write, phone, see, text, email him, or have anybody else do any of those things for you or on your behalf.
Okay.
You're to
That's not a
attend
problem.
AANA twice a week. That's to be in person. You're not to possess firearms. You're not to possess dangerous weapons, no knives. So no contact with Jeremy Roos, no contact with prosecution witnesses or employees of Flat Rock Myers. And you're not to enter or go near 26100 Vreeland in Flat Rock or any other employees of any Meyer. No alcohol, marijuana, or illegal drugs. No firearms, no dangerous weapons, no knives, no alcohol, no marijuana, no illegal drugs. I'm sorry, I'm not giving them a personal bond. 4,010%. You have to post $400. Your court date is March 19th, and that will be at 10:15 in the morning. 10:15 in the morning. So you can make some calls, and they'll let you do that, but you're going to have to come up with $400 to secure your release. If you want a court-appointed petition,
He's filled out, Judge.
okay, good enough. And then make sure you give them an AA verification if you post that bond, officer, okay?
Yes, Your Honor.
Thank you very much. Thank you. Thanks. Give me 1 second here.
He's not the only one who needs 1 second. I need approximately 2 more minutes. We are not going to start the next case with Judge McNally because FelixHoffmanArt, that is the because. And I am looking at 90%. We're almost done here, ladies and gentlemen. I am actually finishing up a little something special that we're going to start pretty directly, as in right now. This is a funny case as promised by FelixHoffmanArt. If it's not a funny case, then you can blame Felix for everything that's about to happen.
Well, I'll just call the case while you're putting it in. So this is case number 2503927 RGC Delano Boatwright versus Karen Graham. Your name? What's your name?
All right, Delano.
Okay.
Kevin Corbin on behalf of the.
Okay, and Miss Graham's here. All right. Well, today is the date set for continuation of trial. We have just a slight issue. We've been looking and cannot find the file notes because we started this apparently. So what I'm going to do today is rely on counsel and Mr. Boatwright to tell me where we were when we stopped last time. We'll pick up from there. And then what I'll have to end up doing is going back and pulling a transcript for this to see, because first time we've ever lost the notes, so I don't know what happened. And I don't know, did we admit any exhibits?
No, we did not. Mr. Boatwright was testifying and he was referring to pictures on his phone, and Your Honor adjourned the case so that he could bring the physical pictures.
Okay, did you do that, Mr. Boatwright? Did you have a copy for everybody?
Well, I didn't copy mine, just wrong one.
Okay, all right,
I have not seen them, Judge.
yeah, so you need to show them to counsel. All right, so take them out of that. Did you mark them as, you probably did not, so. Do we have the stamps on them?
Yeah, it's right here.
Okay, sir, you're gonna mark your exhibits in the order that you would like to admit them, and they're, if I don't know, if I'm sure I may not have admitted them if they were on the phone. So, proposed exhibit, you're gonna be numbers 1, 2, 3, 4, 5. So you could just stamp that, and then when you stamp it, you write in. Sir, you came to trial with no pen? Oh. You at least need that much to take some notes for yourself.
You got 1, 2, 3, 4, 5.
No, I'm just saying your numbers. So however many you have. And while he's looking at those, Mr. Boatwright, do you remember where you left off? He says you're in the process of testifying.
Well, we left, it was showing me an exhibit stating Ms. Graham never received, the receipt. And I had it on my phone, so you told me I needed to print it out and you rescheduled it.
Right, receipt, yeah, okay. So he was cross-examining you?
Yes, he stated that he had a statement that he admitted to court, and I didn't produce a receipt when Ms. Graham asked for one. And I was like, I did produce it, but I had it on my phone, so I had to print it out.
Okay. Counsel, do you need a couple minutes? I wish I'd known that. We could have had that going while we were looking for the notes.
I don't have any objections to any of these, Judge.
Okay, sir, so you intend to admit all of those? Is that your,
Yes, Your Honor.
okay? So how many are there?
13, Your Honor.
Okay, so we'll admit exhibits number 1 through 13 are admitted, and then you'll have to testify, I guess. I think we're on cross-examination, he said. Did he finish his direct case?
Yeah.
So you were cross-examining. Did you need to finish with
Yeah.
those exhibits? Sir, don't put them back in the envelope.
They're right here.
Okay, I was gonna say, because we're about to use those. Okay, raise your right hand. You solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth. Okay, so we're gonna have you sit back up on the stand and we'll go for cross-examination now. Oh, and whenever you're ready, Counsel.
Yeah, and Mr. Boatwright, you testified when we were here last that you didn't replace the speaker, correct? Correct. And, you said that you had a receipt from when you purchased it. May I see the exhibits that you have then?
All of them is what they're saying.
The receipt, sir.
I'm gonna show you what's marked as your exhibit number 9. Okay? Is that your exhibit number 9?
Yeah.
And is that the receipt from when you purchased the?
Both areas.
Well, I know that, but we'll do it one at a time.
Yeah.
Number 9, okay. And this document here says surround 3 speakers, certified factory refurbished, isn't that right? And it says $199.
Yeah, yes, correct.
Okay, but you sued for $1,500.
Another page.
We'll get to that. You sued for $1,500, right? Correct.
No, that was, I took it down to 549.
Oh, well, but your complaint that you filed with the court was for $1,500, wasn't it?
I just changed to 549. I just want replacement for my speed.
Okay, now, this bottom part of exhibit number 9 deals with your subwoofer. And sound bar, isn't that right?
It's a component set.
It's
All together.
it's separate.
No, it's a set. It's a component set.
Well, I understand that. You have suggested that one of your 2 speakers was damaged. Correct?
Correct.
Okay. And so,
It's not 2, it's 5. More than 2. 2 surround, it's a surround, a center, and a subwoofer. So it's a component set.
and you've never replaced it.
Like, no,
All right, but you're looking for damages that include other speakers that were not damaged, correct?
the replacement cost of the system.
Okay, but again, answer my question.
Yes,
Yeah, okay, and that also includes the Cinema 600 sound bar, correct?
yes,
Okay, now you could hook this sound bar and the subwoofer up to any other speakers, couldn't you?
no,
Okay, you still use the speaker that's not broken?
oh, it's not, no,
Okay. Now, you called, and you don't have anybody here to testify about what was wrong with that speaker, isn't that right?
no,
Because you don't have anybody who's technical that will say, this is what's wrong with it, correct?
I have the pictures.
Okay, and you were asked by Ms. Graham to give her information on what's wrong with the speaker, weren't you?
Correct,
And you never did.
it's right here.
Well, all you have is a picture showing
Oh,
that.
I have the proof where she acknowledged she received the receipt. There you go. Put them in.
No, we're not contesting that you sent a receipt. We're not contesting that. Now, this all happened in June of 2025, isn't that right?
No,
When did it happen?
24.
Okay, June of 2024. And prior to that happening, you had sued in a previous lawsuit because you claimed that she didn't have a certificate of occupancy, correct?
No,
Judge, the court could take judicial notice of his prior filing. Case number. (1407060R). And in that case, you sued for $6,500, correct?
do not remember.
And in that case, you claimed trespassing and illegal entry.
Now, what's that case got to do with this one?
What is that?
Well, I'll get to that, Judge.
I get to ask the
Okay.
question, so I need to know because I'm the trier of fact,
Right.
okay? So,
Do you remember filling out an affidavit and claim and saying trespassing, illegal entry? Do you remember that?
I do not remember.
Okay, do you remember saying uninhabitable living conditions? Remember that?
What is that objection?
Well, I'm asking you, do you remember?
okay, what's the relevance? He's objecting and I'm objecting. So what's the relevance of that?
Do you remember in May, just before this happened with the speaker, asking Karen and her son Dante if they wanted to sell the condo? Do you remember that?
Objection, relevance.
Yeah, relevance.
You want me to answer the relevance?
Yes, there was an objection on the floor.
The man files a lawsuit for $6,500. Files another one for $1,500, and he wants to buy the unit. He's doing all of this because he's mad that he had to move and he didn't get a chance to buy the condo.
Oh, that's going to California and you're trying to get to New York.
Well,
So you need to ask him if you're trying to discredit him some kind of way, but telling me the lawsuit doesn't help me.
Well,
You can ask him more directly if that's what you think.
did you want to buy the condo?
relevance, objection.
I think it's very relevant.
Okay, well, I'm not understanding it myself, really. I mean, he has a claim here for a broken speaker. I don't understand why it's relevant that he might have at some point, if he did, try to buy the condo.
He's suing for $1,500.
He says he wants 500. He just testified to that.
Well, but then why did he file a suit for 15?
Well, you can ask him that. I don't know.
Why did you file a suit for $1,500 if you claim that the cost of this entire stereo system that includes the subwoofer and the sound bar and the speakers cost you $549? Why did you sue for $1,500?
Pain and suffering.
Okay. And why did you sue for $6,500 the year before
Objection,
that?
relevance.
Yeah, I sustain. Let's move past that.
I don't have any further questions.
Did you have anything else you wanted to add based upon those questions he just asked you?
To him or to?
Sir, you're not asking him any questions. The way it works in a trial, if you had a lawyer, the lawyer would then be able to follow up and ask you questions that relate to the questions that he just asked. If there was a piece of information that the lawyer figures is important enough for the court to understand something that he just brought out, or if there was something that contradicts it or something. So I'm just asking you, since you don't have a lawyer, is there anything else that you want to add based upon the questions that he just asked you?
He stated that I never provided a receipt. I did provide a receipt to Ms. Graham stating what the product cost, everything, where it was sent to. I provided everything she asked. And you stated I never received it. I mean, she never received that. And this is the response of her saying, is this a purchase receipt? Which I sent to her. And I have the messages showing it went to her. She answered, responds back and said, it is the purchase receipt.
Okay, what else?
I have the pictures. I also have, I have the picture that was sent to her at 6:04 when I first got home at 6 p.m. I explained to Ms. Graham that I would be home at 6. It was my mother at the 6 was my mom's birthday, Juneteenth. So Ms. Graham and a different gentleman came in at 4:32 p.m. I wasn't home. So I got home at 6 p.m. and my speaker was on the ground. I immediately took a picture, which shows right here, it says 6:04 with my speaker on the ground. And as soon as I came in, I informed them about the speaker being broke. First, Ms. Graham was going to check it out, then Dante joined in and they wanted to talk to Jasper, which is the repair person. So they wanted to speak with Jasper.
Who was Jasper?
That's the gentleman that came in to do the repair work.
On your speaker?
No, he had nothing to do with the speaker. He just broke this.
Oh, he was coming in to do repairs in the place. Okay.
It was Ms. Graham and Jasper were only two people that came in. And they were going, Dante said he was going to contact Jasper to give him the information to see what they were going to do about the speakers and repair the speaker.
So Dante is her son.
Yes. They said he's still speaking with the repair person at this point. This was June 25th. He said, we will move to have a resolution at this as soon as possible. Thank you, Delano. I said, okay. Then on June 27th, Ms. Graham said, sorry, I forgot to mention, I want some details to send to Jasper. And that's when I sent Ms. Graham the information that she requested. So Ms. Graham said, she said, thanks, I can send this to the repair person. Then she said, is this your purchase receipt? Then she said, a third person is going to be involved with the speaker. And I said, a third person, don't give my information to anyone other than your attorney. I will give it to your attorney if he asks for it. So as we went back and forth, I explained to I sent a picture to both of them stating, this is what my speakers look like as they were standing up. Then I said, I didn't get her on June 20th. I said, I didn't get a response back about my speaker. It was moved, dropped, and nobody said anything to me. So then, again, I sent, June 25th, I sent another text message, and this is the wireless reference speaker. It said the electrician came in June 19th, 2024. It shows the model number. Dante Graham says on June 25, it say we're still, oh, that was the one I just read, I'm sorry. And then after that, Ms. Graham came back and said, first, the speaker does it produce any sound? Is the cover broken? This is after I already sent the pictures. So she's asking me, is the cover broken? And she says, if we have to go to court, they're gonna want tangible evidence. So that's when I sent all the information, which is tangible evidence. Then she asked me, did I have a sound recording of the speaker? And I testified, I said, no, it's broken. There is no sound. So then Ms. Graham said, is the cover broken? I didn't notice the speaker was broken. Well, I asked her, how could you not notice the speaker was broken? If the picture was on the ground, I sent her a picture as soon as I came in, and it shows the picture clearly on the ground. I mean, the speaker clearly broken on the ground. It sits on a stand.
And your testimony earlier was that speaker is part of a surround sound system.
Yes, Your Honor.
And it's one of two speakers, and then there's a sound bar? Or is there four speakers?
Four, Your Honor.
And is it your testimony that the speaker cannot be individually purchased or replaced from the manufacturer?
Not this one anymore. It discontinued this one. So with here, I asked them in the very beginning, Your Honor, to just replace that part of the speaker. That part, I asked them just replace that single speaker or repair it. But they refused to do it. So then at that point, I wanted the whole thing.
Okay, so at the time you asked them to do that, they would not. Did they have a replacement at that time for the speaker?
Maybe back then in 2024, but this was right after it happened. Yes, Your Honor. To answer that.
Do they still make this?
Not this set, Your Honor. They discontinued this set.
And so so you're just looking for the money that related to the amount that you originally paid?
Yes, Your Honor.
And right now you cannot use the rest of the system?
No, Your
Honor. Okay, anything else that you wanted to add when I interrupted?
No, Your Honor. That's
okay.
Just a couple of questions, Judge.
So this is your recross?
Yeah, just to
Okay.
hold on. So as you sit here well, first of all, describe the sound system that this was hooked up to.
It's a Felix. Felix.
Well, I know.
600 series. It's a
Is it
Felix
hooked up?
600 series. It has 4 speakers. It's a component set.
And it's hooked up to a TV?
It's hooked up. It was
Hooked up to what?
the system.
Well, tell us what's in the system.
It's a component. It's a TV. It's a component set. It's a subwoofer. It's 2 speakers. It's a
What was it hooked up to, sir?
TV.
Your television set?
The TV.
Okay, so it's your testimony as you sit here today. That you've just done without any system hooked up to your TV since this happened a year and a half ago. That's what you're telling the court.
I have another one in the bedroom, but the living room, yes, that's what I'm telling the court.
And you never sought anything from anybody who fixes speakers about what it would cost to fix this speaker.
You can't fix a Felix speaker. I called, you go to the manufacturer. This speaker has to go to the manufacturer.
Did you look at Exhibit 9 and notice that the actual speaker, when you bought it, was refurbished?
This speaker has to be referred, it has to go to the manufacturer.
Objecting, that's all hearsay. He wants you to believe that he's done without a.
How can you object to his that's what he said.
Well, he's telling you what other people, he's saying that you can't replace it. Who told him that?
Felix, the system they discontinued this series.
Well, there you go. That's what he's saying.
You can refer to contact Felix.
Very good. Let's move on.
Okay. Now you're all set? Because this was
Yeah.
recross on one
Did you
question.
finish?
Okay, from my understanding, he was finished earlier there was cross-examination. Then we let him do any rebuttal to whatever you had, and then you asked another question. So do you have anything else you need to add based upon that last question about whether or not you've been doing without a TV, a system hooked up to your TV?
No.
And whether or not you could repair it or got a quote from Clips, because you said you couldn't. Let's go back to the manufacturer.
No, I said you can't, this speaker can't be, it has to go back to the manufacturer. This specific component system right here is discontinued. You can't get this one. So I need the replacement cost of just the system. I'm not
Okay.
asking for 1,500, I'm just asking for the replacement cost.
I understand.
Oh.
And you have anything else you need to say? Okay, then you can step down. Do you have any other witnesses other than yourself?
No.
Okay. Did you, he's resting. I think you're resting your case at this point. Okay. Sir, sit at the table for the plaintiff. You're gonna need to listen to whatever this testimony is, because now you're acting as a lawyer. So you're gonna have to cross-examine or question this witness about things she's about to say. Do you need a pen and paper to write anything down? You're good? Good. Okay. Ma'am, come on over here. Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth.
Yeah.
All right, have a seat. Tell us your name and spell it.
ERANK.
Whenever you're ready.
What's your relationship to this property?
Mr. Hudson, my father, is the landlord.
And who is the landlord? I'm sorry, who is Dante? Right.
Dante Graham owns the condo,
And who is he?
my son.
And, did you have dealings with Mr. Boatwright?
Are you talking about this particular incident or just?
No,
general?
when was the first time you had dealings?
We, leased the place to him. And that was about 3 years ago.
Who leased it to him?
Mr. Hudson.
Okay.
Where's Mr. Hudson now?
Mr. Hudson's in the hospital.
And,
Huh?
in your, how have your dealings been with Mr. Boatwright? Has he been a cooperative tenant?
No.
Why not?
We, it's hard to get into the unit. We had to write a letter to you, for you to get in there to get repairs done. It's been ongoing, it's very frustrating. His demeanor, he can yell and shout. I don't like a lot of controversy, I just don't. So we've given it all. We bought a toilet, the plumber said nothing was wrong with it, we bought another plumber, nothing was wrong with it. Garbage disposal, brand new, break it, fix it, because I don't want to pay for fees, here I am here.
Have you been sued by him before this lawsuit?
Yeah, we were in this court, and he was saying something about asthma, and it hadn't been inspected, and we showed the judge here paperwork, and I felt very good. Really good.
I'm going to show you what's marked as Defendant's Exhibit B and ask you to take a look at them. What is Exhibit B?
Exhibit B is a letter, Mr. Goldwhite from Mr. Hudson, and it says, I'm aware of the repair problem related to the plumbing issues. The condos, as condos do, the pipes are connected, and we need to get in there so they can fix the pipe. Because this is a cooperative, there's some overlap, this is required to fix the plumbing issues. Nevertheless, corporation has taken steps to make certain repairs. At this point, there are problems, because it does not appear they have done anything to do. Unfortunately, you being the occupant, it's necessary to get into the property to make sure that everything is completed properly. My client was.
Why is she reading? Why is she reading this? It's a letter from not her to him. That's hearsay.
This is a letter that was written by my office, Mr. Boatwright. Isn't that correct?
Yeah.
And why was it written?
Well, how did she, excuse me, I'm sorry.
Very good, Judge. I withdraw.
I'm sorry.
I withdraw. the
But I'm gonna follow what I know to be the rules of evidence. And you just can't just throw letters up there and have her read it. When she didn't write it, she didn't, not the recipient of it. Okay,
Do you remember?
so sustain.
My office because Mr. Albright wouldn't let you see his property to fix things.
Yeah.
And is that, what did you do when you contacted my office about him refusing to let anybody come in to fix things?
He did call your office, and, what did I do? I just happened to be in your office, so he called to say that he was coming on Wednesday.
You had my office send a letter to him.
Yeah.
You ever had to do that with any other tenants?
Okay, excuse me. I'm not understanding how difficult of a tenant he is related to whether or not this thing was broken and whether or not she got it, her repair person did it, and whether or not he's entitled to the full amount of the thing, whatever it's broken. How is it? I mean, he can be the worst person in the world, but if they broke something, I'm not sure what this has to do with it.
Well, that's the purpose of closing argument, Judge, and I don't think.
So, but no, I'm not gonna sit here and listen to something that I don't think is relevant.
Very well, we're gonna move along very quick. Did he ever ask you if he could buy the unit?
Yeah.
Okay. This is the unit that he claimed was a health hazard, correct?
Yeah.
And this is a unit that he complained that the city of Southfield.
Okay, when was all of this done? By whom? This is not in evidence. You're testifying about what he said, and there's nobody here that's put this in evidence other than the lawyer.
All right, very good. Let's end the case. Let's end.
Okay, I just want to say, can I say?
No.
Okay, I'm going to say about the speaker broken. Can you ask? me?
Well, that's what we're here for.
Sure. Did he talk to you about the speaker being broken?
Yeah, we went in there June 19th. We fixed the wire. There's a lot of electrical appliances.
Wait a minute. Let me get this. June 19th, you went in?
With the electric. He called because there's a problem. He has lots of power features there. And you can see the burnout. I was concerned because I didn't want the unit burning up. We went in there, we checked it. There was no speaker on the floor when we left. I know his personality. I would have never done that. That speaker was not there on the floor when we left, period. We didn't damage.
Let me ask you a question.
Yeah.
Did you get this information indicating that he would be back at a time that he wanted to meet you around 6 o'clock? So why would you go earlier if you got that?
When he called, we had set the appointment with the electrician. He's had prior to things where we go in to fix something. He did not say, do not go in there. He's been at work and said, I'm not gonna show. I mean, in past history, this is.
Okay, but what did you think he meant when he said, I'll be back at 6?
The same thing he said when he's at work, he'll say something, we're in there. Oh, I'll be back at 5, or I'll be back at there.
So you didn't think that he meant wait for me to come in? And so did you have prior approval to just go into his unit without him being there?
Yeah.
And how did you have that?
We talked to him earlier, as it says in his text, he was confirming was this electrician coming that day, and I said yes. But she had 24 hours notice.
You can't object. That's her testimony. If you want to question her about it, you can. But this is her set of the facts as she recalls what happened. You get a chance to get up and cross-examine her about whether that's accurate, right, or something else, or clarify it. But you can't object to what she's saying because that's her testimony.
I did try to figure out with the speaker, his computer, I've never done a report before.
That's fine.
Thank you. We've been good landlords, and it's very frustrating when you're trying to find out, okay, I'll give you benefit of the doubt. The speaker was not on the ground. It was not.
So let me get back to my question.
Sure.
Where was the authority that you had to go in without him being present? You said
My lease does have a 24-hour notice that I can have 24 hours if there's an emergency. Not emergency, 24 hours to go in.
A 24-hour notice.
Yeah, it's in our lease. So we can.
Okay.
And by it being something.
I don't know if anybody even has a lease, but
Yeah, we do. As we even talked.
so, and the lease says you can go in with 24 hours notice without the person being there.
Yes, but we know,
And I
you know.
I mean, he has possession of the property, so I'm unaware of how you get to just go in without okaying it. That's why I'm asking.
He okayed it prior to the second.
But where did he do?
They must have did it on the phone, but it's not here.
Okay.
I don't go anybody's house without their
Okay.
period. And it's, I mean, we said this in the last.
Well, we know you talked about the problem being that you needed to repair it.
Continue to
Okay.
question witness. I think we'll get to what you're looking
Okay, go ahead.
for. Okay, I'm gonna show you what's marked as Exhibit B. Can you tell me what this is?
It's where he says,
No, what is that
oh,
entire thing?
this is the text messages you're saying, is that how, what I came with?
This is the text messages
Mhm.
between you and Mr. Right, and your son, correct?
Mhm.
Your Honor, I move to admit the exhibit.
Well, you gotta show it to him.
I offered to show it to him earlier and he didn't want to see it. I even have to.
This is nothing, this is about a kitchen. This is not about the kitchen.
Well, what are we looking at that for?
This is the entire text chain.
Okay.
Okay.
Well, how does it relate to this issue?
Well, we're gonna get to it.
Well, okay. We're not getting to it unless I admit it, and I have a question about it.
All right, well, then let me ask, okay, what is your question?
My question was, he's objecting, so I need to see how it's relevant. That's all. Trying to do this the right way. So this looks like about different issues that's going on.
If you look at page 2. No, if you look at page 1. On June 18th, Delano Boatwright says, I'm having an electrical problem. Certain outlets in the living room aren't working.
Okay.
All right. And then it follows up with page 2, where Karen Graham says, electrician just emailed me for tomorrow afternoon. So this is very relevant.
Yeah, this is what we're talking about, where she says he's coming at 5 and he says I'll be back at 6.
Correct.
Okay.
Well, I'm just moving to admit it.
Well, yeah, I mean, you got a problem with that? Because that gets to the heart of the issue. I don't need the rest of this probably, but that gets to the heart of the issue about the notice. Did you want to look at the rest of it to see if you got any problem with it? Why do you object?
Because this has nothing to do with the speaker. Not the rest of this, all these copies.
Well, it has to do with, she's saying the speaker was not on the floor and none of this happened, I guess. They're trying to say you made the whole thing up, I guess. It's where I'm getting.
Yes.
And she went in there without your permission, arguably. And that's what you're saying. And I'm asking her questions about how did she get permission. That's when they came up with this exhibit, which is a back and forth conversation via text between you and she, and I guess her son at some point. And part of that relates to what time the electrician was going to come and whether or not she had authority to go in or not.
I can tell Ms. Graham to go in, people out. I said I would be home at 6.
Yeah, that's what you said. And that's what she said. She interpreted one way, you interpreted another way.
I filed a police report saying she shouldn't go in there.
Okay. So basically, that's what they're admitting. Why are you objecting to that?
To her going in?
No, to the exhibit.
That's fine. I was objecting to the rest of, the first page, but now I understand. I don't object to that. I was objecting to the part about the kitchen.
Okay, I'm only going to be looking at that part that we just talked about. Okay, so we'll admit this is Exhibit B admitted for pages, whatever that is, 3 or so, 2 or 3, regarding time, the electrician to come in and permission.
Did it concern you that he had contacted you about an electrical problem?
Yes,
Why?
because he had a lot of not speaker, what do you call it, power strips. And when he said he didn't have any electricity, I was concerned about, a fire or anything like that. And we have, as you know, a reputation of responding fast.
Okay, so now after you received his initial text about the electrical problem, what did you do immediately?
We look for electrician.
Well, but no, you asked him to clean out the track on the screen.
Oh, that was a different issue.
Okay.
I wanted something
Alright.
with the screen door.
Okay, I'm not looking at any of
Thank you.
that.
So now, turning to page 2. You texted him, electrician just emailed me for tomorrow afternoon, correct?
That was Tuesday.
Right. Is that right?
Yeah,
And his response was okay, correct? Isn't that right?
yeah, it was okay.
And then the following morning, you got another text from him saying, good morning, what time is the electrician? Right?
Yeah.
And you said around. Yeah. And he said, it's my mother's birthday. I'll be home at 6, correct?
Yeah,
Did he say, don't come in here?
no,
Had you ever been in there before without him being there?
oh, yeah.
How hard is it to get an electrician to come out to see somebody on a moment's notice?
Very difficult.
And how hard is it once you have that electrician set to come out to contact you and say, well, it's the guy's mother's birthday, come back?
Well, how would you know that? Unless she asked this particular
Very good, very
electrician.
good. I withdraw the question. I withdraw the question. Now, do you have a lease for this property?
Yeah.
I'm gonna show you what's marked as Exhibit A and ask you to take a look at that. Is this the lease with Mr. Boatwright?
Yeah,
Okay, I want to direct your attention to paragraph 7. Right, I need to admit the exhibit.
Sir, have you seen the lease? Okay, show it.
Yes, I am, yes.
You better take a look at it just to make sure.
What they.
I'm confused. Do you want me?
Yeah, he wants to see it.
Object, I can't even read this.
You have a copy on the complaint that you were served with. You want to get that?
Well, if he can't read it, can I read it? Look, because I don't know why we're admitting it if it's not legible. Sir, does that look like it's the lease that you signed?
No,
Well, what's different about it?
I can't really read this. It's all blurred, blacked out.
Okay. Could you go?
Your Honor, I believe there are other copies was with the papers that were left before it last time.
Oh, I can't read this either. I see what he's talking about.
Oh, no, I do too.
Yeah. It's some of the words are you can't even make them out. Do you have another? You don't have another copy?
Yes, I do. He was served with summons and complaint. He left it on. He could go and get it.
Yeah, to give that back to him. I can't. That no, you can't read it.
I agree.
It's not that it's small. It's just something wrong with it.
Here last.
Mm-hmm.
I don't know what you, so that maybe with your other documents that.
Yeah, we're gonna look for that. I don't know. My sister, I've been looking for an hour. She couldn't find anything. We've never lost any notes before, so that's a first. Okay, so show him that one. Can you read that one better, sir?
I object. I'm not sure this is the lease I had.
You're okay. You're not sure if it's the lease you have.
There were several different leases and one didn't say the same thing because one was dropped off and I think her niece dropped it off and then I received another.
Okay. Well, did you have the copy that you think is the right one?
It's outside. I didn't think to bring leases.
Outside where?
In the truck. I think I have one in the truck.
Okay.
Well, I
Well,
didn't think I needed to bring leases.
Well, we'll certainly let you, I mean, this is what they're saying is the lease. You can cross-examine her about the lease, and then I'll let you bring in whatever you got that you believe is the proper lease, if there's more than one. I don't know. Did you sign this one?
I'm not sure if that's the one. It was several. I signed a couple of
Do
them.
you see a signature on it? You signed a couple.
Yes, because they changed, one was sent to, it looks like my initials.
Okay. Well, I think that would maybe go to the weight of it, not the admissibility of it. If she can identify it, we'll let it in. So go ahead, counsel.
And know from the last time he was there.
I mean, I have my paperwork, we send them certified. And he signed.
But looking at this
Oh,
document,
I'm sorry.
do you notice anything about the dates?
We had the same lease every year. It hasn't changed or anything.
Look at paragraph 7.
Oh.
Read to yourself paragraph 7.
Okay, I'm gonna probably need a little refresher on this. So,
Okay, the first, agree on signs, the one, the notice, 24.
Lower, you gotta be quiet a little bit, because I can't hear this lady.
Oh, to my field,
Get here.
Okay, I believe there.
What does paragraph 7 deal with?
Give the landlord permission to enter the premises, giving them 24-hour notice for the purpose of inspecting. Or if there's some major, repairs, like plumbing, that are detrimental to damage, and also, like, if there's major electrical things that can cause some kind of
Is
damage.
that what the lease says?
No, I'm trying to figure, you can just ask me a question.
Paragraph
Lease says,
7.
Okay, yeah, the lease will speak for
I didn't know if
itself.
I could
The
read
lease-
it or not, but you said the other time. don't
Your Honor,
I
have
don't
you
know.
admitted, I think you said that.
I said if she could identify that's the lease
Yeah.
that you had with the plaintiff.
I do have certified receipts that you got.
Okay, well, I'm gonna admit this one. And if you have another one, then of course we'll let you go get it and ask her about that. Okay?
So what? Was it ever communicated to you that he didn't want you to go into that unit?
No,
What did you interpret him saying? It's my mother's birthday.
I
Well-
interpreted that as other occasions, when he's at work, we tell him we're going in there, he'll say something like, oh, I'm working late, or something came up. And we've done repair work that he's requested.
So what does that mean? You've gone in anyway?
Talk to him, and I guess as this was stated.
Well, his question to you was, what did you think it meant by it's my mother's birthday, I'll be back at 6? And you said like similar situations where
Yeah,
something came up and
Yeah.
I'm asking you, well, what do you mean by that? Are you saying you just went in,
no.
he tell you something and you just go on in anyway?
No, we do not do that ever.
So what did you interpret that then? I'm back to his
I'm
question.
sorry, I interpreted that when he said it's my mother's birthday, I'll be back home at 6. If Mr. Boatwright does not want you in somewhere, he will tell you.
So why do you think he said that then?
I have no idea why he said.
Okay, so
But he said that.
you didn't attribute any meaning to the fact he said that.
I didn't attribute any meaning that he meant not to go in there.
Mhm.
And did you try to get further information on this broken speaker?
Yeah.
What did you ask about?
Well, this is the layout. Information about the speaker. He says it's broken. The speaker that was not laying on the floor on the left. You know, I called the electrician to find out, to double check. And I also like when I call electricians or people to have all the information, so I don't have to make another phone call. So I'm trying to find out. Does the speaker, I'm not a speaker person, but is the woofer working, is the speaker working? When you plug it up, what happens? No response. And this has been characteristic of him all while he's been sitting with us. It's always no response. We have to get people in there to counteract or say whatever it is he's saying. I'm sorry, it's very frustrating. Because in a court, I've never been in court and I really don't know what to say or what examples I can give or I can't hear. And we went through that whole arena about the infection, if it was infected. He even didn't tell the truth here. Thank God.
Okay, well, you don't have to try to figure out what to say. He's gonna ask you a question. Okay.
Thank you. It just gets a little.
Yeah.
Looking at page 5 of the text message exhibit B, did you text him questions? Dr. Whitaker?
Yeah.
Tell the court some of the questions you texted him.
I try to get scaffold the conversation saying, first, does the speaker produce any sound? Is the cover book?
Did he respond to the question, does the speaker produce any sound?
No.
All right, what's the next question?
Is the cover broken?
Was there a response?
No.
What's the next question?
And do you have a recording of sound quality that demonstrated ineffectiveness of sound, for example?
Did he answer that?
No.
Did he ever suggest to you, why don't you come and listen to it?
No.
He called the police because you went in his unit, right?
He said he did, but I don't know. I've never been contacted by him. Lisa.
We don't have any further questions.
All right, you have questions for this witness?
Yes.
And did you need to, let me ask you this, did you need to go get your other lease if you think that's not the right lease? Okay, all right.
Oh,
Why don't you? Yeah, maybe go to the podium.
Ms. Graham, you stated that I was extremely particular, correct?
What do you mean by particular?
Your word. You said I was extremely particular and you would not leave a speaker or anything on the ground because of how particular I was. You testified to that, correct?
I will say that your demeanor is very, I don't mean particular, I'll check rephrase. Your demeanor is.
Not demeanor.
No, I'm gonna say what your demeanor is frightening. That's only, I can't think of another way to put it. So I make sure that nothing is out of place. My only regret is that I should have talked with the victim. I didn't think it was that big of a deal because it was fixed. I was
Okay,
concerned
ma'am,
about-
wait, there's no question posed. The question he asked was about him being particular. I'm not sure he answered that, but you said something about he frightens you.
Yeah.
Okay, next question.
Can I ask a quick part? So
Ask her again then.
you stated the record that I'm extremely particular and you would not leave a speaker on the ground because I'm extremely particular.
Did you say
Did
that?
you say that?
Yeah, I used the wrong word.
Thank you. So can I can I give this to her or give it to you, Ryan?
I do, what is it?
It's just the state, our text message and the proof that I have.
Well, ask her, are you trying to ask her, are you trying to get some information from her about this?
Yeah.
Then ask her the question and if she could show it to her and say, does she recall this?
Thank you. Ms. Graham.
And what number is that?
This is number 1.
Okay,
It's very number 1. Can you
exhibit
read
1.
that, please, Ms. Graham?
Good morning. What time is the electrician coming today? Around 5. It's my mother's birthday. I will be back home at 6.
Now, what does the picture show?
It shows a speaker on the ground. This picture shows a speaker.
What time does it say?
A speaker is on the ground somewhere at 6:05. It was not at my unit.
That's 6:05. What time? What day?
PM.
So that's the actual day the electrician was there. 4 minutes after 6 o'clock, there was a speaker on the ground, correct?
The speaker was actually done way before 6. The time you have
That's
the speaker.
is correct.
You got the photos. What time?
No,
Ma'am, you just have to answer the question. Excuse me, stop. You don't argue with him.
Thank you.
You just answer the question.
I did not, I don't know. What is the question?
Repeat it.
The question is, it's 6:04. Is that not the speaker on the ground the day you and the electrician came in 4 minutes after 6
I
o'clock.
thought it was 6:05.
6:04.
Okay.
The speaker was not on the ground when we left.
So that's not, you said that's not a picture of your unit?
I
You
would
just
know.
testified, said
It
that's not a
doesn't
picture
look
of your
like my
unit.
unit, but I'm saying
Judge.
that
Objecting.
She did say it wasn't her unit. I heard her say it. It's a picture somewhere and it's not my unit. She said it. So he can ask about that.
Ms. Graham,
Overruled.
another picture. Is that not your unit?
to be honest, I can't tell.
Is this not your unit?
I still can't tell. Because you got a wall here. I don't see your sofa.
That's against the wall.
I'm gonna object, and she can only testify to what was the condition when she
There
was
was
there.
no speaker.
She said the speaker was not on the ground.
That's what she said.
It fell after-
This is cross-examination. Excuse me. It's cross-examination. He can press her.
So this is not the wall as well. This is still not your unit, Ms. Graham?
It's a speaker up against the wall.
Is that your
No,
unit?
I can't testify truthfully to say it's against my wall. When I left, the speaker was not on the floor.
That's the picture. Okay, so can you tell me, you said I never received, you said you never received the receipt when you asked for the receipt. What does that say, Ms. Graham?
I never said I never received a receipt, number one.
So you don't get the information that you asked for.
I
To
did not
repair a
receive,
speaker.
no, I asked for the damage. Was there any sound effectiveness? Was there a problem with how it's operated? Those were the questions that I was asking.
You asked, did I have information on the speaker? You said I did not, your counsel said I did not provide any receipt.
You
That
provide-
you testified, right? You say in that statement that is this a purchase receipt? Is that not what you say?
Is this a purchase receipt?
Is that not what you said? That's your name, Ms. Graham?
The damage is clear. This is what you are saying, not me.
I'm asking you what you said, Ms.
Thank,
Graham.
I can send this to the repair person. Is this your purchase receipt?
So you did receive the purchase receipt.
I received the receipt. I did not receive any information on how this speaker was broken.
Okay,
The quality of how it operates.
Ms. Graham. Again, stated you never got any information. Could you read this for me, please? Your counsel stated I never sent you any information when you requested about the damage of the speaker. Could you please read that?
Whatever this company wires references that the speaker, this is the speaker that was broken by the electrician on June 19th, 2024. The model is shown. He can replace or repair it possibly. We are still speaking with the repairman at this point about their speaker. We'll have the resolution as soon as possible.
If you did not break the speaker,
Oh, I'm sorry.
did not break the speaker, why would you need to continue to speak to a repair person?
I wanted to know all the details from your perspective and from his perspective.
But you
I
said the
always-
speaker was never on the ground, was
It
right?
wasn't on the ground.
So why would you need to speak to the repair person? You would have said that's not true.
No, I wouldn't. You know me. No, I
Oh,
won't.
no.
I always.
Yes, ma'am. Here we go. Please read this.
Is the cover broken? I didn't notice the speaker was broken. I didn't notice, these are text messages, but they're short and sweet. I didn't notice the speaker was broken. It was not. However, you have to be cooperative with information if you want to be paid. That's only said if we go to small claims court. I had not spoken to the electrician at that particular point in time. It was not on the floor. Now, if you said he damaged it, I called him and I asked him about it. He said he did not damage
Question for you, Ms.
it. After this,
How many people entered the unit on that day when you were doing the repairs?
that I know of. I don't know. I can only testify. I can only testify for when Jasper, the electrician, and I were there. I don't know because we left before 6.
Thank you.
I don't know if you had somebody in there at 6, or if you in there before there. If you have somebody in there at 6, I do not know.
Graham, who was this coming in? Who are these people? That's the day of the repair.
And these are all exhibits that are admitted. Is that correct?
Yes, yes.
Because you're not really referencing for my purposes, because I got to look at this. And I don't know what she's looking at. So you need to say, look at, ma'am, stop. When you hear people talking, why would you keep talking?
I'm sorry. This is very frustrating.
Yeah, I get it. Sir, when you hand her something, you need to tell us which exhibit she's looking at so that we all know. And if you want me to look at it, I have no idea what you're showing her. It's just that there are a bunch of different things we've admitted. So it'd be very helpful for you to at least direct the court and counsel to what number it is you're talking about when you're having her look at them. That's all I'm saying. So what number is that?
That would be exhibit number 6, Your Honor.
Okay.
So what was the question again?
Who are the people,
Who is the first?
who are the people coming in on the repair date? The
On
two people.
exhibit number 6 is one person in the building. I don't know if it's my building, there's no number, there's no time on when this person came in here. On this,
Are you sure that's your building as well?
there's no address here.
So is that not you? You know, the
This
second.
one looks like me. This one,
So you're not sure if that's you, Ms. Brown?
I did not say that.
I'm
I said
asking
this
you, so
one-
you're not sure.
Ma'am, are you sure?
Is it you or not?
I said, you said exhibit 6. Are we on exhibit 2 now?
I guess so.
Is that you?
She's telling me that
You're relevant.
I don't know if it is or not.
She said that she went in with the
She said she didn't know if that was her.
No,
That's what she stated.
I said on number, can I say this again?
Number 6.
Number 6, there's a person at the door with no time on here. I don't know if it's our unit that this person was at. Now, does he want me to talk about number 2 now?
I guess so. Go
Is
ahead.
that you in picture number 2?
This is, it looks like me. I guess it's me, number 2.
So that's a yes or no?
Yes,
That's you in number 2. Is that not Jasper, the repair person in exhibit number 6?
it looks like him. I mean, this is 2 years ago. I'm
So is that a
gonna say,
yes or no?
that's a yes.
So it's Jasper and that is you, and both exhibit number 6 and exhibit number 2.
At 4:23 PM.
And I
This
had
one
told
has
you I would
no
be
time.
home at what time? 6 p.m.?
We were out of there before, way before 6 PM.
I told you I would be home at 6 p.m., correct?
You said, you didn't say 6 PM exactly. Let me listen to what it says.
Here we go. Exhibit number 1. Please read exhibit number 1.
Mhm.
Please read exhibit number 1.
It's my mother's birthday. I will be back home in 6.
There we go. So I was correct. You said I will be home at 6. Ms. Graham, I want you to read exhibit number 13.
We are looking into this with the repair person. That's why I've taken a while to respond.
So you're looking into a repair person, even though you didn't break anything, correct?
Wait.
Your Honor.
And no, we're not breaking
What, is that a question?
Yeah, apparently it
That was
was.
a question.
What's the
I'm
object? Hold on. Stop.
It's argumentative. It's not a question. Of course she was looking into it. That's what a reasonable person does.
This is her testimony. His cousin's there.
Go right ahead.
So
Let's keep this.
go ahead.
May I respond to this?
To respond to what?
He's saying something like, yes, we're looking into with the repair.
Yeah, he's asked you a question about
What
it.
is
He
it?
said, the question was, why would you be looking into something with a repair person if you didn't believe you broke it in the first place?
I said the speaker was not on the ground, and what we did was, I was looking at different units, so I wanted to double check to make sure that something didn't happen during that time period that we were there.
So Ms. Graham, at any point, at any time, did you ever tell me you did not break the speaker?
Yeah,
Other than, no,
oh, yeah,
in the text.
not in a
message?
text message.
That's right. Please read exhibit number 3.
Someone, as it said, someone dropped my speaker and broke it. Both my speakers were like that when I left. I didn't get a response about the speaker that was moved, just dropped and broke it, just left it, didn't tell me that it was. I'm just reading, that's where it stops.
So did you not receive information about the speaker being broke and repairs or the model and information from me, because counsel testified that I never responded and gave you the receipt or the information or pictures showing that the speaker was broken on the ground. Counsel testified that I never.
Okay, first of all, the council doesn't testify. He's not a witness to anything.
Step number one, the first part. You said the model number receipt, and you said I am not to share that with anyone. Number two,
Except your attorney.
yes, but
Read it.
I still gotta share it with someone to see what's going on. But let me finish. And as far as being broken, I said I was investigated, because it was not like that. Again, I tried to find out from the electrician, did anything happen while I was looking at the other unit? When I called him, he said no. These are clear pictures. They were not like this when we left. That's my testimony. They
Yes,
were
ma'am.
not like that when we left.
Testified only 2 people went in that unit at that time. You and Mr. Jasper.
During a time frame, when did we leave? I mean, I can't answer questions, I'm sorry. We left probably, you know what time we left. We were not there. There's plenty of opportunity for either you to, someone to put this the way it was.
Ms. Graham,
So wait a minute, so,
I'm sorry. He-
so,
he said
wait a
we
minute,
were
let me
not
just
there.
make sure you're clear. You're saying you think he broke or
I'm
the
gonna say
speaker,
one thing.
so he could get the price of the speaker from you?
Someone dropped my speaker and broke it.
Okay.
It was not me.
does that picture show and say it was 2 speakers and that's the way both speakers look?
This is a still picture. You
Does
got
that- does
video,
that- does
no,
that-
let me finish.
does the
I'm
text say-
testifying. Somebody dropped my speaker and broke it. Both speakers were like that when I left. You're asking me, was I acknowledging that I broke the speaker, or correct me if I'm wrong? I said, no, I didn't. Yes, I did get a receipt. Yes, I did email you to say what is wrong with the speaker. You if it's something wrong, and if he did call me back and say, hey, you know what, Mrs. Graham, I broke the speaker. So I need to know information so that company can pay for getting the speaker fixed. So I do ask.
What make you think that company is gonna tell you the truth, whether if they broke it or not?
Bad luck with any company doing that.
Okay.
I'm just, Mr. Hutchins is in 2093, and he has connections. People will come and do that. I don't know how to explain.
But I'm just trying to,
Oh,
I'm just trying to understand why you have such faith that if the man told you he didn't break it, that he was
No,
telling
he
you the
didn't tell
truth.
me he didn't break it until after I called. I was getting information in case.
Right, why do you think that was the truth, though?
Oh, well,
You just believed him?
when I left.
Because you're saying he must have done it because you didn't see it. How do you know this gentleman's telling the truth?
When we left, my testimony is when I left, it did not look like this. It did not look like this when we left.
4 minutes into me entering the unit, I took a picture of a speaker.
Okay, we're not testifying right now, sir. You've already said that earlier. You're just really asking her questions. Now, you've asked her a lot of questions. She stuck by her story. So your job is to get factual information from her.
Yes.
About what she knows, how she thinks what happened here.
Yes.
So are you done with that part?
No, so your testimony is, I broke the speaker to get money, but the electrician you spoke to, did he refuse to repair the speaker or replace it?
Well, let me correct that. I didn't say that.
Yes.
I said the covers, the speakers did not look like this. They were on there when we left.
Said I broke it.
No, I just said what you said. Someone dropped my speaker and broke it.
Oh, thank you. And someone, there was only 2 people that went into that unit at that time.
You don't know that.
I have a ring camera. You testified it's only you and Jasper.
No, we were gone. We weren't there that long.
So you're testifying that someone
We
came
got
in
there.
after
What
you
time
left
did
and
you
did
say
it?
we got there?
So now someone came in after you left and did it?
I have no idea what goes on in your unit. I have absolutely no idea. We were there according to your document. What time were we there? It was 4 something. It did not take him long to fix this particular burnt wire in your unit.
So Ms. Graham, were you with the repair person the whole time?
I just testified that I was with him the majority of the time.
So you
Let me-
left out?
Let me finish my statement, because you're confusing me. We went in the kitchen, I called him in the kitchen, we looked in there. When we left, the cup, it did not look like this.
So the question was, were you with him? I thought you said you left and
Yes,
went
I
to
did look
another
at them.
unit.
I might have been gone for a minute or two.
Okay, that's what he's looking for.
Oh,
Thank you. So is it true that during that time, the repair person could have broke my speaker and you didn't know?
I don't know. I can't answer it. Because
Yes or no?
I do not know if he broke your speaker.
Is it
All I
possible
know
that
is
he could
that-
have broke the speaker while you were gone?
I don't know. I'm gonna say no. I don't know.
So it's not possible he could have broke the speaker while you were gone?
That's like me saying, is it possible?
No, is it possible?
for you to come in and say?
Your Honor.
Ma'am, to answer the question.
Is it possible for the electrician to have broken the speaker when you left?
I can say that the cover was
Your
on.
Honor.
No, I'm trying to get it in my head to answer this question. Are you saying that he put are you implying that he put the cover back on?
No, ma'am, it's an easy question.
Yes, I guess somebody could have broken it. Someone could have. I'm just gonna say someone could.
The electrician who he was asking
The
about.
electrician, he said he could have. Like I said, if I known it's gonna be this intense, I would have brought him in.
So he said he could have, and you believe he could have while you left.
I don't believe he could have when I left, but
So if you're the lease owner, the leaser, is it not your responsibility to watch a repair person when they enter the unit? Yes or no?
I don't know what that means. Did he repair? I don't know what he's talking about.
He said, is it your responsibility under the lease, I guess, to watch the repair person when he comes into the unit?
There's nothing in my lease saying that, but I mean, we can go revisit that. However, we
Yes
tried to go,
or
no,
no?
it's not in my lease that says.
Not the lease, not the lease. Is it your responsibility to
The
watch
lease
the
is my
repair person?
responsibility.
Is it
No,
your
no,
responsibility?
No, then it's no.
So it's not your responsibility to watch a repair person that enters the unit?
My responsibility is to find someone to fix something that is broken in your unit. I did let you know 24 hours ahead of time, and giving you for someone to come in there.
So
Because of the issue of it being an electrical issue with all the power things going on, yes, I was concerned about a fire.
So,
And as I said before, it was burnout.
so it's not your testimony that it's not your responsibility to watch a repair person that comes into the unit to repair something. You left the unit. Is that not negligence for you to leave someone in my unit or the unit that I inhabit? You left someone in the unit that I pay to inhabit. You left them there. My equipment was broken. You said it was possible.
Is this a question? It's very long. You have to state it shortly.
It's not your responsibility to watch a repair.
Is that a question?
Yes.
She said that, yes. Sustain. She already answered that. She said no.
No more questions.
Let me ask you a couple of questions. Think very carefully about what happened here. Was the speaker on the ground when you left his apartment?
No, it was not.
Was the electrician there after you left the apartment?
No,
So, and did you ask the electrician if something happened to that speaker?
my words were.
That's a yes or no
Oh,
question.
oh. Say it again. I'm trying.
Well, he complained about the speaker, correct?
Yeah,
And you found out about this after you had already left.
yeah.
Did you contact the electrician and say, did something happen to his speaker?
Yeah.
Okay, and what did the electrician say?
Which is hearsay. Out of court statement used to prove the truth of the matter asserted, and he ain't here for cross-examination.
Okay. Did he put it back together maybe? And so when you left, it wasn't observable?
Did he put it back together?
This is
You're just adding facts in that nobody's testified to.
any case that I've ever tried in my entire career.
Okay.
Okay, all right, so, I don't have any further questions.
Okay.
Let's do closing arguments.
You don't have any other witness? This is your only witness?
No other witness.
Okay, ma'am,
We're gonna spend this.
you can
We're
step
not
down.
spending any more time.
He has no more witnesses.
Okay.
Do you have any other rebuttal witness? Watch out, ma'am. I'm
Yeah.
sorry.
I'm sorry, did you want the receipt, the certified letter receipt that? It's so confusing.
Whatever your lawyer has admitted is fine.
Okay.
He's in charge of that.
I didn't know.
Excuse me, sir. Can you have the exhibits?
The one she still had. Or you done with it?
Yeah, whatever she had.
He's in here, I can't.
Did you still want to say you wanted to send?
Sir, why would you admit some exhibits and don't give it to the person who's deciding the case? Yes, you need to give them to me if they've been admitted.
Not a fourth person either.
Well, you know what you're doing though, as far as what you want somebody to look at. Just come on up here.
I'm trying to get out of here.
He's not gonna arrest you. You're fine. So my question to you is, do you have any rebuttal witness, which would probably be yourself, to anything that she just testified to? Since you were acting as a lawyer a minute ago, asking questions, now you can act as a factual witness and say, this was accurate or this wasn't accurate of what she testified to. So if you want to, you can get up there and rebut it. Something, if you have something to rebut. And you're still under oath. What's your name again?
Don't.
Okay. You're still on oath. You don't have to raise your hand. What do you want to say in rebuttal?
In the rebuttal, Ms. Brown stated that she left the repair person there. It could
I'm
have
gonna
been.
object, Your Honor, assumes facts, not in evidence. She never said she left the repairman and didn't.
Yes, she did.
But she didn't say she left the apartment.
She
said
did.
She was alone. She saw that the speaker was.
Excuse me, counsel. One thing I'm known for is taking very copious notes. And she did say that she left out of the apartment to go to another apartment for a minute. And she said that.
Then I misunderstood.
That's what you said. And then you said at one point, yeah, you went into another room too. You said both.
Then I misunderstood that.
Well, I don't know. That's what's in evidence. So go ahead, sir.
That was my rebuttal. She stated someone left. I mean, she left the unit and left the repair person there. So at that time, the speaker could have been damaged, and that's negligent for you to leave a repair person in a unit and you're not there. And my equipment got damaged, and I just want to be replaced. That's it for me, Robert.
Okay. That's his only question.
All right, well, let's do closing.
Are you done?
I don't have
No,
any-
okay.
no.
Step down. Okay, so now that everyone's finished with their evidence, we're gonna go to the closing arguments. Closing arguments are just that. It's an argument which tends to summarize what the evidence showed. And most people, when they're giving their closing, they try to tailor the closing toward their side, but they can address inconsistencies or issues that they saw in the other person's proofs, and then basically give the court a synopsis of what it is they would like the court to rule. So you kind of sort of giving me your perspective on what did the evidence show. Your opening is what do you intend to show? Your closing is what did you show, or what did the other side show that supports your theory of the case. So I need to kind of summarize that. So go ahead.
That's fine. In closing, if I stated in the beginning, I would not be home until 6 p.m. So I did not tell anyone to go in until 6. If When I left, my speakers were both on the stand. I came home at 6 p.m. and 4 minutes later, I took a picture and sent it 4 minutes later, as soon as I came in. Ms. Graham stated she was unsure this was her unit. She stated she left someone there in the unit. She said she's not sure if he broke it or not. So I wanted my speaker to be replaced. If you leave someone in a unit and you say you're not sure if they broke something or not, that's negligence, because you should not leave someone in a unit working if you're going to leave that unit. And my equipment got damaged. And in the event, I presented it to her immediately. I didn't wait 6 hours. I contacted her 4 minutes after me entering the unit and provided pictures for her. I provided all the information that was needed for her to make a decision. I spoke with her, I spoke with Dante on several occasions. I gave them everything they needed to get this taken care of. If you leave someone in a unit and something gets broken, you're responsible for it. Your Honor. No one else came in that unit besides those two, as she testified. It was only her and Jasper. So when I left, there was a picture of both my speakers on the stand. When I come back, one is on the ground. And if you didn't notice the speaker on the ground as she testified, I can see that because you left somebody there. That's why you didn't notice it on the ground, I believe, because you were not there, according to your testimony.
Okay. And so what is it that you're looking for?
That's the replacement of the system for 549, Your Honor.
All right, is that, you're all set? Okay, defense.
Yes, we heard a lot of more argument than we did testimony. Here's what happened in this case. First and foremost, the man filed a lawsuit for $1,500. Okay, how do you settle with somebody who asked for $1,500 and then comes to court at trial and asks for $529? He also
49, I think he said.
He also claimed that she broke into the condo. He thought he called the police about this. Okay, but the most unbelievable part of this case is that they could both be correct about something, and it is offensive that he assumes that she's lying. And that is, if you look at the photographs, Judge, this is a little speaker that's on a very little stand. What probably happened here is that the electrician knocked it over and then set it back up, but didn't do it right, and the speaker fell again. It's not the speaker, the whole thing, the stand and everything laying on its side. It's the little speaker that's on the top of this very narrow thing. So that's probably what happened here. And that's consistent with all facts. Karen Graham stated that when she left the apartment, he did not go in there after she left, and that the speaker was standing up and was right. And it's very consistent that perhaps the electrician did knock it over and did damage it and tried to put it back together. Listen, a toddler does stuff like that. Break something and, well, I'll just set it back up where it was, and nobody will know the difference. That's entirely possible. But what you can't get past in this case is the incredible lack of information related to damages, and quite frankly, unbelievable information. This is a man that cares enough about his technology equipment to have two full systems. One, a TV in his bedroom that has this big sound system attached to it, and another one in his living room. He wants the court to believe that the last year and a half, well, he's just done without the system in that room. No, the speaker works. It's sitting at his house. He's trying to get some money, trying to get $1,500. He hasn't brought it in to show you that it's not working or damaged. He hasn't, and let's go back a step and let's look at the receipts that you have that are in evidence. Those receipts indicate two purchases
One for $199.
I don't even know if I got the
What
receipt.
you do? I think it's either page 8 or page 9, because there's 2 receipts, pages 8 and page 9.
Okay, hold on.
And
You said let's look at them. I'm trying to find them. Page, you mean exhibit 8 or 9?
yeah, it-
Here's 7, 11, 6.
anyway,
Sir, I need all the exhibits. Why are you holding some back?
they were on the folder. I didn't.
Oh, yeah, just give them to me. Okay.
If you look at the receipts, you
Mhm.
see product name, surround 3 speakers, $199.
Mhm.
Then below that, there's another item, which is the 600 soundbar and wireless subwoofer. He wants a whole new stereo system for a speaker that we don't even know is broken. It clearly from his photographs, I don't think that he would fabricate a speaker being on the ground and make all of this up that it never really happened, but he's gonna say that it happened. But what he is making up is this silliness that this destroyed his whole system, a system that he has never replaced, and that he wants $549 or whatever the amount is. No, the speakers cost $199, and that's for all the speakers to the system. So if he has any damages, it'll be $199.
Mhm.
And quite frankly, Judge, half of that, because he has half a speaker. Look.
Well, I guess his argument, from what I could understand when he was testifying, is that you can't use the other part of the system without the speakers. So if he got the money for the speaker, he would have been happy when he could have gotten that. He could have replaced it. That's what he said. And he said it was discontinued though. So when he asked her for that, they didn't give him the money. Then he said it was discontinued since then, so he can't get the speaker itself and he can't get the whole system anymore. So he just, since it's unusable, he said, that's why he wants the 549.
We can look at the credibility of a man who filed a case for $1,500, when admittedly, the case isn't worth $1,500.
He said pain and suffering.
And he also filed a previous lawsuit that was dismissed. And he also, and this is why.
We're not relating to this.
And this is why your ruling on not being able to question him about buying a unit is so mountainous. This from a guy who constantly complains about everything, but says, hey, you're gonna sell it, I might buy it. This is an individual trying to get a payday. That just like he's trying to buy this unit and constantly complaining about what poor condition it's in to try and get them to sell it to him.
Well, you just said earlier, now you're saying he was trying to get a payday. You just said earlier, you don't think that he would have just manufactured the speaker on the floor within moments of getting home. You just said you didn't think he did that. Now you're saying he's trying to get a payday.
Well, I mean, Judge, well, let me explain it to you, okay? I'm saying, I feel it's pretty clear that this speaker was on the ground when he came home. What's unclear, and in my opinion, completely unbelievable, is that this destroyed his entire sound system, and therefore he had to replace everything. Yet he.
What evidence do we have other than his testimony? I know, but we don't have anything that's saying that's not true.
He has the burden of proof, Judge.
But he said it, so that's some evidence of it.
Well, but if he's not believable, and I maintain he's clearly not believable, because first of all, again, for him to have all this equipment, and yet, well, this is an attempt to get the
Okay.
money. He was hoping.
Well, let me say this. This is an aside from your argument. I get people that come in here for all kind of things that don't replace things until the lawsuit. It could be 2 years later. They want to get the money first. So I don't know if that means that he didn't go without it or that he's lying, because that does happen. People do wait till they get to the actual court without spending any money. Mm-hmm.
If he gets $549, we'll come by and pick up the broken
system that he has, okay?
Okay,
Because it ain't broken and he's still using it. He's trying to get money.
okay.
That's what's the truth.
All right. I could ask him to bring me the system and let me examine it. You still got it? You do?
Yeah.
Okay. Okay,
That's fine right there.
sir, that's not appropriate.
And my client will buy it, Judge. He can bring it in and my client will give him the $549 for it.
So I need to hold this thing. Did you want to make any extra statement? Because you get the last word anyway, since you're the plaintiff.
I'm this terrible person. First, I'm looking for a payday, like I'm broke, indigent. Then I have all this extravagant.
But this is not a major payday. It's 100. It's either 199 or 549. It's not that much, but
I'm trying to buy the condo, so apparently I must have some financial means, but then I'm a scammer and I'm just looking for a payday. Can't have it both ways.
okay.
Judge, sure you can. Sure you can.
I'm asking him for his final word.
Well, he should
I just
bring the
want
system
my- I just want
in, my client will
system
come in with a
replaced.
shot for it. $549.
He just offered you a settlement. He said, bring the system in and they'll pay $549. Well, if that's the settlement, then I don't have to resolve it. If that's,
When do you bring it in?
yeah, sir, bring it. You can bring it in here. When you gonna bring it?
The date?
Yeah, I'm gonna give you a date.
Give me a date out here.
Okay.
Bring a check.
Somebody with a date.
Bring a check.
Somebody with a date. So we'll settle this like that.
Leave that.
So meantime, I will hold on to all this.
How long does?
How long it take you to pack it up and get here?
I'm going home. I'm home. Well, no, I'm sorry. I have to go back to work today. I'll pack it up.
We're not gonna do it. That
No, I'm just saying I'll pack it up today.
Okay.
You said, when you come back, it'll be here.
soon as you want to.
Whatever day you said.
And that's all components.
Thursday? Okay.
All right, and the way I heard the settlement, you bring it in, they give you a check. There's no checking it to see nothing. You just taking it for $549. Okay. All right.
And court's available, March 5th at 2 p.m.
Yeah, that's in 2 days.
March 5th.
Yeah, how
2 p.m.
He's just bringing it in. Well, counsel, we know you're busy. Give us a date when you think you're ready. I mean, what's all of that other stuff, letter?
Well, one of them just can't, he had a motion for summary and they just withdrew the motion.
For today?
No. Oh, you talking about what time is, I think it's at 2.
2:30.
Look at through the absolute of March 13.
I know.
What are you doing this afternoon?
Oh, I gotta get back to my office. My secretary called in.
Oh, okay. She what?
She called in sick.
Oh, yeah, I know how that feels. Shit. I can't do anything without her. March 13th?
That's fine. We have a bench trial, but that's fine.
What's another day?
We don't have.
Yeah, we're pretty busy around here.
Yeah, March is actually booked like almost every day. So the 13th, is it just to?
They're gonna settle this thing.
Right.
No, I'm not going on the record.
Okay.
We're just gonna let them come here. Well, I'm gonna stick Charles out there on them. So there's no fighting.
No, I ain't worried about that.
Okay.
Ain't gonna happen.
Okay, March 13th at 1:30.
1:30.
The 13th at 1:30.
Okay, March 13th at 1:30 is the
Do I have
next
to put
thing.
this on the docket or?
Yeah, put it
Yeah.
on there.
Okay.
Very good. Thank you.
Okay. March 13th. I better watch that tape just in case. Never know. But no, it's settled. I mean, they did it on the record, so. All right, thank you very much.
Felix, thank you very much. Thank you very much, Felix. Everybody in the chat, tell Felix, thank you very much. We had a whole other show set up to watch that was full of some very dry but interesting Judge Simpson landlord-tenant docket cases and a kind of a heart tugger, we're gonna watch the Brandt case. Don't you worry. That is an interesting case with Judge Middleton. I don't know when we're gonna do it yet. We may do it on Saturday, probably Saturday. Saturday's show is actually really shaping up, ladies and gentlemen. So I hope you're around, and I hope you come by for the rest of the week. Same old time, same old channel. And I have more court. And thank you, Felix. Thank you, Felix. Every so often when we are drudging through the court cases of the day, somebody in chat will be like, hey, did you see this thing that happened? We should all watch that, and we should do it live. And ladies and gentlemen, that's what we have done tonight. And I do appreciate your patience and your camaraderie and all of your chats, man. Rhonda, it's been fun. Felix, it's been fun. Dobby, I haven't seen you until just now. Welcome, Crafty, Patrick, Matt, JB, GB, Mama, I know you're out there. Becky, everybody, and most especially Rhonda. Rhonda, I haven't forgotten about your amazing contribution with the super chat. Thank you so much for that. I can't say thank you enough. Ladies and gentlemen, I am your humble Methuselah. Well, humble sometimes. And I am your curator for these here videos. I'm your host for whatever I do here. And you know what? I'm out. I'll have a good night. We'll see you guys. Have you ever noticed that someone driving slower than you is an idiot? Anybody driving faster than you is a maniac? Yeah.